Hello, happy Monday, and coming in here at you with a little bit of hard work, trying to get back my brain back into work mode in this last little run up to Christmas. So today was my first day back at work, and wanted to welcome you back because I was noticing that a lot of the law community, as it may be, is running into a lot of different issues. Let's just say dramas and difficulties and boredom, and they're all covering the same thing and reading stuff. And I was thinking, reflecting, I'm like, I don't really want to do that. I don't really want to comment on trials necessarily. I don't want to commentate politics. I don't want to read you motions. I don't want to, I want to give you stuff that's unique to this channel, and something that's creative and different and gives you a little different perspective, get you out of the news cycle, and gets you out of whatever's going on in the world. Now, I think that I've decided that I may, if I'm going to help out on trial streams, it should be Florida criminal trial streams, because I'm a Florida criminal trial lawyer. And I also do appeals. And just so that everybody knows, if you don't know who I am, my name's Steve Gosney, and I've had over 7,000 criminal cases. I've had about 80 jury trials where I've been the lead trial counsel, both on the prosecution side and the defense side. I've had over 500 appeals, criminal appeals. So, my specialization is criminal trial. I train our appellate division. I am board certified criminal trial law. I help out in the trial division on strategizing and things. So I want to comment on trials that I might have something to say about, or at least qualified. I feel comfortable. Everybody's asking me to comment on trials that are out of state, non-criminal trials, things like that. And I would say that that's not really my wheelhouse. So, or at least, my comfort zone. I mean, I need a lot to be comfortable. Before I say something, I'm very careful. And I'm currently practicing, and this is my hobby. And I was thinking, well, am I interested even in doing law content at all? Now, I know a lot of you all are criminal trial people, and you're interested in trials. And I know that you look to me as somebody who is in the inside, and that's true. I get it. But you got to understand is that's my job. And I don't really see this as being, I want this to be enjoyable for me as well as to you, right? However, that being said, one of the things I do like is I like intellectual discussions about law. And I like, I enjoy writing, because I write about things that are of interest to me, an academic interest, right? So, and I've developed that over time, as you well know. And Ideas and Answers in Law, which was my first book, is very hardcore law, right? So I was thinking about, well, okay, I know that the suitcase murder trial is coming up, and then the OnlyFans murder trial down in South Florida. Those I will probably be interested in. Oh, and good to see you. Yes, and I'll do some musical. I've got the great Steve Hayward, who is a professor from Berkeley, he's been on before. You might know he's on Powerline, and we're going to go through ranking the Genesis albums. I need his help because he's a prog guy, and I got to say, I'm over my head on ranking the Gabriel Errol Genesis. So that's coming up in early December. And I've got some ideas for, different things I might want to do. But I know that people are interested in what I have to say about law because of maybe my unique position on the interwebs or the law tubes or whatever. And I don't want to get involved in dramas or any of that stuff, right? I mean, I'm interested in the academic side. I'm interested in what I'm interested in. So I'm trying to really contemplating what I'm going to do. All right. So we'll talk more about that at the end. But what I've developed for you today, because people by demand, they say, I want to hear more law stuff from Gosney. All right, fair enough. So I'm going to give it to you. You got your pencil? Got your yellow stickies? Okay. What I want to do is go back to Ideas and Answers in Law, and we're going to go through the battery article. And the battery article is a chapter in Ideas and Answers in Law. Now, when I first set up this channel, it was to promote Ideas and Answers Law, and I did a quick summary of the different chapters, but I didn't really do the deep dive. Okay, so today we're going to go through this in an atomized, intellectual, law school level discussion, and it will be a discussion so deep that it will be basically deeper than most criminal trial lawyers, prosecutors, defense attorneys, and judges. Most of them have not thought about this issue as much as I've gone through on this. And I'd say this is probably, it's Simple Battery by Slight Touch on page 45. So if you have your book, you can get it out and follow along. I've taken that article, I've edited out some of the stuff, a lot of stuff to make it a little more readable and verbal, and so we can interact and talk about it. But I think of all the articles, this one is the most important. Now, why do I say important? Because battery, simple battery, is one of the most common criminal charges out there. It's all over the place. Misdemeanor battery, right? And felony battery. Battery is, touching somebody against their will, right? That is a crime, and it is a very common crime. And sadly, it is one that is not well understood and not well thought through. And I think that this will give you also some insight into my writing process and how I write, why I write, and what writing to me, when I say writing is an exercise in thinking, why this article came about and what I have to say about it. Now, I will tell you that I believe very strongly that the ideas that I will convey to you are correct. And this article is law review caliber and can be cited cited or used by a criminal defense lawyer, by a prosecutor, by a judge in Florida to explain the battery statute. However, these are ultimately my ideas. It's an academic law review type article. So take this, it's like, well, Ghazni, I'm not giving legal advice here. I'm giving academic analysis of the battery statute in Florida. And it's very important. Now, why do I write? Before we get to that, let's say as we said, the personal stuff, I'll put some more, we'll talk some more stuff at the end. So I know that I like to put the business end up front. And then if you want to hang out a little bit, we'll see how long I go after that. But this might take a little time because I want to do it very carefully with you. Got your pencil? Gotcha. All right. What is the inspiration of this article? Well, there is a particular prosecutor who I envision, and they didn't even do that. They didn't even do this. But I can envision this prosecutor who annoys me quite a bit doing this. And the vision of this prosecutor doing it, combined with the fact that I've seen prosecutors do this, drives me batty. And something in the back of my head says there's something wrong with it. What am I talking about? Well, you'll see them get up in front of a jury during jury selection and just say, the law in Florida is that a battery, all it takes is a slight touch, just a slight touch, just like that, just a touch, right? And that's a crime. You must, now you're the jury and you have to follow the law. So if we just prove the little slight touch. Now, the reason that they say this is because in law school, they had a bar exam question in criminal law, their first class in law school. They got that question right because somebody came along and they slightly touched and that's a crime and I've identified it. And I got that question right on my multiple choice exam. And they feel real proud that they know something about Florida law. Did you know that it just takes a slight touch, right? And then so now they know something. They got the question right on the test. So that's the law, right? And then the judges, they're just prosecutors who've been prosecuting the same stuff forever. And they've got that question right too. So everybody thinks, and the defense attorneys, everybody thinks that this is what the law is. The law is a slight, just a little touch, right? All right, now my argument, and now something bothers me about that. I'm saying there's a number of reasons. We'll go through the examples of why this is problematic. But that bothers me. And I'm like, when I hear this, it annoys me because I know something's wrong and I'm an intuitive thinker and I intuit that something is wrong with that scenario and that statement. But okay, it's one thing to criticize. It's another to answer the question. Ideas and answers in law, right? So I set about discovering, is that a true statement? Is that a true statement, or is it not a true statement? All right, well, I'll jump to the conclusion to say that is an incomplete statement of the law. It is correct as far as it goes, but it's incomplete as a complete statement of the law of battery by slight touching. Now, understand that in Florida, we call battery the touch, all right? We call assault the putting in fear of an unwanted touch, all right? So in an assault case, what we call assault in Florida is somebody pulls back and is going to hit you like this and you flinch, okay? The crime is the anticipation and the fear of being touched, right? Against your will. The battery is that you're actually touched. Now, you don't need to see it coming. You could just be bopped on the top back of the head and you didn't see it coming. There's no anticipation of the fear, but it's the touch that's the crime. All right, now other jurisdictions have different definitions. Some of them call assault battery and battery assault, right? Or basically assault is battery in those jurisdictions, right? But understand Florida is the touch is the battery, the anticipated touch is the assault. So when I talk about battery by slight touching, I mean just the touch, all right? We're going to go through the statute. Now, we're going to go through the actual, the article, all right? Let's look at this. We're going to go through it together, okay? And you see that? Maybe my buddies can tell me how to make, let me see, I wonder if this would work. Web layout, print layout. Okay. Now, this article I did in, like I said, it's in the book. So this with Christopher Jenks, who's an MD. I'll show you. I asked him to audition. He was a nice fellow who volunteered to help me write some of the portions on this that had to do with the medical portions. I might have taken some of that out for this purposes, but mostly, so here it is. And so all I have to do is brush someone on it, just battery. Objection, misstatement of the law, but is that objection well taken? The fact that a slight touch is enough to constitute battery is taught in Florida law schools to first-year law students to repeat back on their criminal file exams. Beginning prosecutors often pick up the language to teach the jury the law of battery. And then here's the problem. Once they say that, then they add it. They say, okay, now you as the jury must follow the law. You have sworn to uphold the law. And even if you think it's stupid, you must follow the law. And there's a lot of jurors that are like, yeah, I swore to uphold the law, and the law is a little touch, like a slight touch is a battery. Therefore, I must vote guilty, right? So this is a problem. You see? Let's keep moving. So here is the Florida statutes. It's Florida statute section 784.03 sub 1A1, Florida statutes. Okay, Florida statutes define misdemeanor simple battery as when a person, quote, actually and intentionally touches or strikes another person against the will of the other. Okay, you got it? When a person actually and intentionally touches or strikes another person against the will of the other. That's battery. Seems real simple. So now in common law and in basically the law, criminal law, you have an act combined with a requisite mental intent to form a crime. So all crimes must have an act and an intent. So those two combined, mens rea and actus reus is what that's called in Latin. All right, so you must have an intent, criminal intent, and you must act on that intent. So my just sitting here scheming, planning on killing somebody is not good enough. But if I act on it and I have the intent, that's the crime. Or conversely, if I accidentally kill somebody, like let's say I'm driving on the car and I go to sleep and I run somebody over and kill them, but I had no intent to kill them, that's not a crime. That's an accident. You see, but the intent, driving the car with intent to kill, actually running somebody over, put those two together, now you have a crime. So in battery, the act is the touch upon another without their consent. So there's two parts of that. The defendant intends to touch, and the defendant must intend that touch to be non-consensual. Okay, so for example, Danielle's in the chat. If I gave Danielle a hug, if I thought, well, Danielle would, I think that she's going to consent to that hug because she's my buddy and she's my mentoree, but she actually does not want a hug. All right. Well, my intent is to touch, but my intent is not, my intent is for it to be consensual. But in fact, if she thinks it's non-consensual, that's one thing, but my intent must that it be non-consensual, you see? So an intent to touch alone is insufficient for criminality to attach, because the slight touch, the person you would expect to be consented to, would not contain any criminal intent on the part of the toucher. And the law prohibits punishment of an innocent mind. Got it? Okay, so here's the Florida jury instruction. The offensive battery occurs when a person actually and intentionally and it touches or strikes another person and against the will of the other. It's actually, what it says is actually and intentionally touched or struck a victim against their will. But the and only occurs between the third and fourth phrase there. So that means touches or strikes another person and against the will of the other. Or the and is actually between 2 and 3. I'm sorry. Actually and intentionally touches or strikes another person against the will of the other. But that and is distributed through all 4 of these. So it's actually, I actually touch. I intentionally touch. I touch or strike another person and against the will of that person. So those ands combine to make these elements more comprehensive, all right? But let's delve even further, all right? So distributing the rule of statutory construction, distribution rule, actually and intentionally must be applied to each act of the touch itself and as well as against the victim's will. So when that happens, we go actually touches or strikes, intentionally touches or strikes, actually against the will, and intentionally against the will. Okay, so we're breaking that, we're further applying our mental state to the acts. Actually touches and strikes, intentionally struck. Like if I actually touched person, but I didn't mean to touch you, that's number 2, right? I did not intentionally touch you. Oh, I'm sorry. Didn't mean to touch you. That void number 2. Actually against the will. So again, let's use the Danielle statement, right? She was offended. She didn't want me to hug her, right? But I didn't intend for it to be against her will. Now, if I did, if I knew, she says, don't you hug me, my mentor. You're my mentor. You're not supposed to hug. And I did it anyway. Now I know it's against her will, and then it's intentionally against the will of another. Okay? But let's further expand this. All right. Now, this is where we're getting into the deep dive. And I will tell you, most criminal lawyers do not understand it in this depth. But it's important to understand it in this depth so that and if you're a lawyer, a criminal lawyer, I really want you to pay attention because I believe this is the law. And it's important to know the complete law of battery in order that you not wrongfully convict or prosecute somebody, or if you're defending against these things, that you know how to weed out the element that is not present, that the prosecutor is prosecuting an innocent person. So I'm going to add some additional language. Okay, so here's my 1, 2, 3, 4. But look at 3 is broken out into A and B. Okay, let's add it again. Defendant actually touched the victim, actually touched, intentionally touched. I meant to touch. It's not just an accident. I actually touched the victim against their will. All right, so touch. But look at these 2, okay? The state must prove the touching was actually against the will, and this is a real important one, the state must prove that an objectively reasonable person would not have consented to the touching in the totality of the circumstances. Okay, and this B element is the one that is often overlooked. And this is the one, without this law will result in absurd results. Because think about it. So that means that, okay, so I touch somebody, but let's say like it's shaking hands in an office meeting. I meant to touch them. I intentionally touched them. It was against their will, right? And they testify, yeah, that was against my will. And I knew they didn't want to shake hands, but I shook their hand anyway. Without B, that would be a crime, a first-degree misdemeanor crime punishable by up to a year in jail. Now, if you look in a business meeting, that person that doesn't want to shake my hand is not acting as an objectively reasonable person. So an objectively reasonable person would consent to that type of touching in the totality of the circumstances, right? Otherwise, we are all subject to the whim of the eggshell victim, the person who is so sensitive to everything. I can't believe they touched me. I don't know if you've ever seen, there's a video of like this cop, and this woman's like bopping the cop with this little balloon or something, and the cop's just standing there, and this like blue hair is going bing, 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 and the cop takes the thing and like pushes it, and she falls down going, ah, right? It's ridiculous. So the thing is, would an objectively reasonable person consent in that scenario? So it has to be not just whether they didn't consent, would an objectively reasonable person? That is a really important element that gets forgotten about or overlooked or not paid attention to. All right, so let's go through these one by one. Defendant actually touched the victim. That's the basis. That's the act. Slight touch. And this is where the slight touch is correct. It does not take a violent, injurious thrust of the fist in Florida. Now, some states do. Model Penal Code does provide that that there be some modicum of injury. All right? And it says right there, does not follow the Model Penal Code. Require injury for criminal charges. Only requires minimal contact. And that's extended. Now, recognize this extends to touching of clothing, vehicles, anything intimately connected to the person, extensions to the person. I'll tell you, it's funny because I came up with this. I was outside I was walking outside a restaurant, just coming home after lunch. I forget I met somebody for lunch at Stavros. You know who you are. And I was walking, and I was getting dizzy. I sometimes get dizzy. And I just leaned against the person's car because I was so dizzy. And this woman was in the car, and she was on her cell phone. I didn't know. And she's like, "What are you doing touching my car?" And it shocked me. I was like, "What?" There's somebody there like, "Why don't they mean to touch the car?" But I actually intended to touch a car. It wasn't with her consent. But is that a battery? The car is an extension of her. What if she ran out and she was some kind of Karen? She's like, "That man touched my car and shook it without my consent and everything." Well, is it objectively reasonable that I might brace myself against a car when I get a little dizzy? All right. I'm just saying that this is an important element. All right. But actually touching is the first thing. Got it. Slight touch. Intentional. I must intend to touch. So that's like you'll see it in a law school exam. Somebody's having an epileptic seizure and they're flopping around and they hit somebody during their epileptic seizure. Well, the person that's having, like, say I'm having this epileptic seizure, I don't intend to hit them, right? What if I trip and fall and accidentally touch somebody as I fall down? That was an accident. Now you got a lot of times says, "Yeah, I meant to hit him." Okay, yeah, I meant to touch him. That's an admission. Keep your mouth shut. Okay. Yeah, and like a fist punch is obviously that's like the intent is clear, but a slight touch can be a brush, against somebody. We had a case in our office where this guy is just trying to, like, he gets cornered and the cops are standing in their way. They got him trapped in this corner. And my client was not under suspicion for anything. And he tries to leave. He tries to get away, like move. And the cop blocks him and he brushes against her as he walks past. And it's like, "It's a battery. You're under arrest." All right. Actually touched victim against their will. Now, this one here is the touching was against the will of the victim. Now, that one there, this is our third element. This one's got to be broken down into two things. The first thing is the victim themselves is going to come in and say, "It was against my will." That's 3A. Actually against the victim's subjective will. It doesn't have to be objective. That person subjectively said it was against my will. So they got to come in and testify that. Now, this comes, a lot of times this comes into when you have a domestic battery situation, when you've got a couple that's fighting. And what if the other party says, yeah, we fight like that all the time. I didn't object. It was with my consent that I got hit, even though the cop saw it. If the victim themselves, the touchy themselves, comes in and says, I don't mind getting hit. We do that all the time. I like it. All right. Does that defeat element 3A? You understand? The touchy themselves must come in and say it was out without their consent. If it's not, then what you do is you attach an affidavit to the battery saying dismiss it because that element wasn't met. It was with the consent of the touchy. Got it? Now, it's interesting because because the state wants their cake and eats it too right here, because a lot of times they say, well, it doesn't matter that the victim that consents or not. Their consent was objectively unreasonable. Okay, so like a woman in a battered spouse situation, she may say, oh yeah, I would like to get beat, but that's objectively unreasonable. So from an objective person standard, it doesn't matter what the victim testifies to as long as it's objectively unreasonable. But see, in that case, that's where element 3B comes in, where, well, then if that's the case, state, then it should also be that if it's objectively reasonable, then it's legal. You can't have it one way and not the other. Okay, think about what I'm saying here. If you have a domestic violence situation, this is where this comes in play a lot in a criminal case, domestic violence situation, and one party comes in and says, no, I want him to hit me. The state has got to dismiss that case, right? But then the state counters that. Then they say, no, but it was an objectively unreasonable touching. Okay, if that's true, then an objectively reasonable touching is also not criminal, regardless of what the touchy says. So if the touchy says, I didn't consent, 3A, but it was objectively reasonable touching, 3B, then that's not a crime. So but I'm suggesting that it's both. It requires the touchy's lack of consent and an objectively reasonable lack of consent. All right. So let's think about this. So here's the idea. Bikini-clad woman walks past a man in a pool. The man spanks her as she passes. Shocked by this, the surrounding witnesses call 911 and the spanker is arrested for battery. All of the witnesses testify no reasonable person would consent to that spank. The spankee testifies that she has an unusual kink. She enjoys being spanked by strangers in public. The court would be obliged to dismiss that charge since the state has not proven the spankee did not subjectively consent, even though everybody agrees that nobody would like that. That should be subject to dismissal. Got it? Now here's another one. Two men face off in a bar. They say, stop, separate. One of the fellows pokes the other in the chest during the argument. Boom. Everybody would say no reasonable person would consent to being poked in the chest in the surrounding circumstances. That's the objective 3B. But the touchy says, oh, we were just rough arguing. The poke wasn't against my will. This is how they regularly argue. He consents. So it must actually be against the will of the touchy. Does this make sense? Am I making sense here? Now let's look at 3B. In addition to 3A, they also have to show the state must prove an objectively reasonable person would not have consented to the touching in the totality of the circumstances. Okay, prosecutors are often relied upon to use common sense when bringing charges. Ha, ha, ha. However, in the case of a slight touch, the surrounding circumstances of the slight touch may be determinatively important. Okay, so let's think about it. A person comes up to a mall security guard, taps him on the shoulder to report suspicious activity. Guard turns around and says, I didn't consent to that touching. Without element 3B, the state could submit this fact scenario to the jury and the jury could convict. So you have to have the objectively reasonable prophylactic procedure to allow for a dismissal when an objectively reasonable person would consent, or it would not be unconsensual. It's a double negative. Lawyers love double negatives. Such a touch would not be objectionable in any reasonable circumstances. All right. That makes sense? Now, there's a lot of, if you have ideas and answers in law, there's a lot of footnotes here that give case law support for a lot of this. All right. Now, here's another way to look at 3B. 3B is objectively reasonable touch, or the state must prove that it was not or is not unreasonable. It's a double negative on there. All right. Think about the idea of implied consent and sports. So you've got a rugby game, and that's a contact sport. Players are consenting in that forum to being tackled, pushed, and grabbed in a way that's unacceptable in most other contexts. So if a rugby player files a battery charge against his opponent for tackling him, the defense would be implied consent. All right. Now, a rugby player who got tackled, he'd say, I didn't want to be tackled. The tackler, he intended to tackle him. He knew the guy didn't want to be tackled. And the guy said, I didn't want to be tackled. Right? So all of the elements of a battery are met. But given the totality of the circumstances, the doctrine of implied, in a rugby game, that is part of a reasonable person. For an objectively reasonable thing to happen during a rugby game is for somebody to be tackled. Now, if you tackled somebody not in a rugby game, that would be a battery. But in the context of a rugby game, it is objectively reasonable, even though that's why if you've got to have 3B, you've got to have 3B. Like, here's another one. Oh, well, and actually this one goes to, remember the hockey player who did the side kick with the blade to the neck and killed the other hockey player? I think that was in England. Now, I consented in a hockey game to being elbowed and tackled and checked, and maybe even a hockey cup or puck hit me in the chest or whatever else, right? But he did not consent to being kicked with a blade in the neck. So that would not be objectively reasonable given the real rules of a hockey game. Similarly, and this article was written before that incident, but that's a good example. What if the state says they can prove it with external testimony? The guy's being running down the thing and says, don't tackle me, and he gets tackled anyway. Without the objective standard, that's a battery. Because he'd say, no, implied consent was overridden by his verbal commands to the other player to stop and don't tackle me. Right? It's got to be, 3B has got to be there. Same thing, like now you look at a different context. Basketball, it's more rough and stuff, but you don't expect to get smashed or kicked or stomped in the head. But a kickboxing match, you would expect to get punched, kicked, and stomped, right? MMA match. How about when I go to a mosh pit in a heavy metal concert? I'm implying to get moshed, boom, boom, bumped. But I'm not intent people. I don't want somebody to smash me in the head. But it's the context of the music. I'm in a heavy metal concert. But if I go to a classical concert and start moshing, that's not going to be right? It depends on the circumstance. So without 3B, objectively reasonable touches can be criminalized. And that exceeds. Now, here's my argument. And that makes sense, doesn't it? Does this make sense to y'all? But that exceeds the state's constitutional police power. And I'll talk about why that is. And I think that these elements are correct. Now, D is that fourth, the state must prove the defendant intentionally touched the victim against her will, or the intended touch that would be objectively unreasonable under the totality of the circumstances. And this has to be, what did I intend? Did I intend to touch somebody against their will? And that's a mental mens rea state. That means I must know that the other person is not consenting. There's some case law here I'm going to skip. Now, element 4, my intent to touch against their will, that has to be there, because otherwise all touches become batteries. I must intend to commit battery. Otherwise, it's strict liability, and the law disfavors strict liability. That's because moral blameworthiness. Crime is basically punishing bad acts, criminal minds plus bad acts. There's some other justifications I have here. About now, here's some other angles that I want you to consider on this. Touch is common in everyday lives as human beings and affects every aspect of our daily lives. Touch is required for human happiness, and a lack of touch causes human harm. Now, I'm going to say that my medical degreed friend helped me with this somewhat. I had the concept, but he got some of the footnotes in here. Some of these parts are expanded in the book. The sensation of touch provides crucial information about the world around us to the point that some researchers call it the fifth sense. Touch experience begins in the 4th to 7th week of intrauterine life. Shortly after birth, the medical community places newborn child to skin with a mother to promote bonding. Touch is essential to the growth and development of a child, helps alleviate stress and pain. Touch can increase camaraderie and validation, like in an athletic team. Fist bumps, chest bumps, wet towel snaps, slap on the behind, extra low high five. These are all touches that increase the cohesiveness of a group. Touch can convey emotions, can build and maintain relationships, convey other emotions. An interesting study, participants touched an unacquainted person, and that person was then asked to decode the person's intent based on the type of touch. And that person was able to decode the emotional intent with surprising accuracy. So then what happens if touch is withheld? Withholding touch is called touch deprivation or touch starvation by the medical community. And just as touch improves a child's neurodevelopmental skills, lack of touch impedes it. This is all basically from my medical doctor here. So the no matter how slight dictum behind the crime of battery is irrational if not qualified by a reasonable person in the totality of the circumstances standard, since everyday human life contains and requires touching. The scope of individual freedom must have room for slight touching between individuals. You understand? Now, it's interesting because this echoes, I don't even know whether I wrote this before or after my book Prepare, but as I was preparing for today's little lecture, I note that this echoes some of my ideas about individual freedom in my second book, Prepare. But I would just say that this has to do with unenumerated rights. I think that we have. Is it a fundamental right to slightly touch another if that touch is reasonable in the totality of the circumstances? And if it's is that an unenumerated right? If it is, the state can't interfere with us as citizens, us as individual human beings, touching others in a reasonable way in the totality of the circumstances. And by the state enforcing stupidity, by criminalizing slight touches in certain situations, you are. Now think about, well, how could this be done? What if there's a cop in his uniform standing there like this, blocking an entrance in a mosh pit or wherever, in front of the Capitol building, let's say, and he stands there and people come brushing by one or another. And he's saying, I don't consent to any of that. And he comes in and he testifies that he didn't consent to any of those touches. Are you going to criminalize everybody that came up and brushed against him? We're going to videotape every citizen. And I didn't consent to any of those. And that cop's going to screw you, the citizen. We have to be very careful with this type of broad reading of criminal statutes because it's a mix, a recipe for government targeting of individuals that they don't like. Exactly, at a Ginger concert. The fact, could the state, for example, outlaw all touching? I'm saying that such a law is inconsistent with the constitutional framework. All right. This concept of individual requires a zone of individual autonomy. Free men should be allowed to thrive under freedom, and that should not be subject to arbitrary state power. Tyranny is excessive and unnecessary state intrusions into the zone of liberty. So the state cannot outlaw all touch, is what I'm saying. And a basic tenet of statutory construction compels a court to interpret a statute so as to avoid construction that would result in unreasonable, harsh, or absurd consequences. And a broad definition of this Florida's battery framework, a broad definition, would subject every person to a criminal charge for living in everyday situations. And basically the citizenry would be held in fear of the most thin-skinned people among us, the blue hairs, the Karens, who scream and yell because, oh my God, I got caught. Ah! Really? That's the world we want to live in? Or should we instead live in a world that's got a larger zone of individual freedom? So let's assume that that statute is broadly construed so that the state has lots of power and they can regulate these kind of simple touches that are objectively or subjectively a reasonable touch in a circumstance, right? Well, then could they outlaw a doctor visit, a subway ride, a crowded concert, a movie theater row, a tap on the shoulder to get someone's attention, a pat on the back? All examples of touches that are slight, unwanted, but objectively reasonable. The inherent messiness of life results in slight touches. Now you say, well, this is just a misdemeanor world, and this is the way the public defender looks. Most of you guys are good law-abiding citizens, and even a misdemeanor battery charge would be hell, and you would hate it. But let me tell you, it can be bootstrapped. In Florida, there's all kinds of felonies that can be done, that can be leveraging a slight touch into a felony. For example, conviction, 2 slight touchings make you a convicted felon. 5 years in prison. Slight touching battery, if the person's 65 years of age or older, is a felony. If the victim's pregnant, that's a 2nd-degree felony. Battery by slight touching on any of the following is a felony in Florida. You slightly touch a law enforcement officer, slightly touch a firefighter, emergency medical provider, railroad special officer, traffic accident investigation officer, non-sworn law enforcement agency employee certified, blood alcohol analyst, breath test operator, law enforcement explorer, traffic enforcement officer, parking enforcement specialist, blah, 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 blah. All of these people makes it a felony. Your little slight touch that you think, oh, this is not a big deal. And I'll tell you, we deal with this all the time when it becomes to law enforcement and cops who want to criminalize, leverage into felonies, things that are just simple batteries. But no, I'm a law enforcement. I was wearing my insignia and I didn't consent. And they're wrangling somebody and somebody's flashing around and they hit them accidentally, they touch them. All of a sudden, it's a felony on a slight touch. We deal with that all the time in the public defender's office. It's because this broad statute that is used to terrorize the public. I'm just, can you see, I've dealt with this too much. If unchecked by the reasonable person standard, a felony conviction would require only an unreasonable victim and an unreasonable prosecutor. Now, let me ask you, that unreasonable victim could be a cop and an unreasonable prosecutor, and they don't like our client. Do you think that combination, and then it goes to the jury? All it takes is a slight touch. And you must follow the law, jury. And the cop gets up there in his big uniform and says, I didn't consent, and he touched me. That's a crime. You got to follow the law. You got an unreasonable prosecutor? You don't think that happens in Florida? So here's the model that I'm saying. This is what it should be. Now, like I said, we don't have prosecutors that follow it. We don't have prosecutors that fully understand this because they got it right on their first law school exam in criminal law and first year law school. And so did the judges and so did the defense attorneys. And they haven't looked at it since then, and they never really thought about it. And gee, I know the law because I'm a great lawyer because I prosecute all the people. And this slight touch, that's a crime. And they never thought about it more than this. And when they deal with a slight touching situation, they haven't thought through it. So think through it. This is the elements of the crime. Defendant actually touched the victim, intentionally touched the victim, actually touched the victim against their will, and the state must prove the touching was actually against the victim's subjective will, and objectively reasonable person would not have consented to the touching in the totality of the circumstances. 3A and 3B are critical. And 4, defendant intentionally touched the victim against their will. Defendant actually knew or should have known the touching was actually against the victim's will under the totality of the circumstances. Got it? So, what do you think? So this is a problem. Most Florida criminal practitioners have not thought through this criminal statute sufficiently to really understand the elements because they want to convict people. They want to get them. I'm saying that individual liberty needs to be a little bit broader than that, and that we need to be very careful with a statute that could be very easily abused and used as a weapon of tyranny against individual freedom. And it is being used by unreasonable prosecutors and unreasonable cops and judges and prosecutors and defense attorneys that don't understand the statute in a in-depth way. This is the way it should be. Now, I'm not saying like there are cases. I'm just telling you, there are lots of cases where people get prosecuted and one of these elements is not present and it doesn't get caught, it doesn't get dismissed, and they get convicted. All right. But this is one of the chapters in Ideas and Answers in Law. And I wrote it because you can see it gets me jazzed up, because to me, that's an injustice in the system. It's not, I mean, think about it. Are we really losing a lot of control over our society by carving out this little exception, by making the state prove a little bit more than what they may think? Is that really so overwhelming that the world's going to go to the cats and the dogs? Or is it a dangerous statute that needs to be strictly looked at? When we're talking about a slight touching, they need to be damn sure that that is a crime, because otherwise we're running the danger of making criminals out of people who are not. And that's we're talking about the deprivation of freedom here. It fires me up. And that's why I wrote this article. And I think that not many people have looked at that in this way. And I would encourage, if you're a prosecutor, a judge, or a defense attorney, or a juror, to educate yourself on what the crime actually entails and read my article and apply it. Now, I've given you that there's a lot of footnotes and there's a lot more back support to this. But I think it's important, very important. All right. Well, let's see. So, any questions, class? Did you get your pencils out? Have we got that pretty good? I haven't been following chat here because I've been ranting, so I apologize for that. If you would like to, you can return to bring it forward. So I don't look like there's any super chats or any Rumble rants. Well, see, here's one thing. Okay, people get confused. What if there's no body cam view? He said, she said. Yes, that's true. It would be he said, she said, except for the fact that testimony is evidence. People don't understand this. Somebody saying a she said is direct evidence of the touching. So if she says, that's sufficient. I have people that have gone to prison for life based on the single testimony of one witness. And in fact, there's another article in Ideas and Answers in Law that addresses that very fact. And it is called One Witness Cases with an Under Oath Contradiction, page 103 of Ideas and Answers in Law. So these maybe I'll address that in some future episode of what did I call this? Like Law Masterclass. Okay. Is this a Law Masterclass? So I want you to really look at this and think about this. So Ideas and Answers in Law. Lots of these are available. All right. What do we got here? Let's see. Oh, I wanted to, so we're moving out. So you can stop it now. You can stop watching now if you want to move along and go do your thing. It's just us friendly chatters now, all my buddies. I haven't said hello to all of our good friends here who've shown up. But, oh, I wanted to tell you, so I sent my comic book to CGC Comics. Ian Runkle had said I needed to send my comic book, my Silver Surfer #1, to get graded. So if you can see, there's a little short video only on YouTube, and I put it up on, I don't know, it was a little short. It's the only way I could, my son videotaped it. And you can see me showing the comic book, and I sent it off. So we'll see how this process goes. KLI says, this is a very good question. After listening to Ginger Song, can I sue them for assault? Possibly. Now, you're talking about suing somebody. It's a civil matter. Can you charge them criminally for assault? Probably not. You could probably sue them, though, in a civil context. Most crimes are also civil torts, which is a whole nother topic. What else we got here? I think we're good. Let me see. I had a bunch of stuff that I wanted to tell you about. Oh, so I've shipped out. Okay, the remaining Brucey books will be coming in on Thursday. So I'll get them shipped out on Friday, I expect. So anybody who doesn't have one shipped already, the remaining ones will go out on Friday. And it's Brucey the One-Eyed Wonder Dog. I've also given the thumbs up to a Brucey the One-Eyed Wonder Dog coloring book that will be soft cover, black and white pages interior, that will be for your kids if you want to. It'll be a cheaper version of Brucey, same content, but in black and white, and be able to color with crayons or watercolors or paint or whatever. And it'll be black and white. So that's kind of cool. And then, so I gave the thumbs up. I'm going to front it's going to cost me some more money to get it done, but I think it's a good idea. I kind of want to see the coloring book, and it'll give you all another option to buy Brucey at a little less expensive. Because the reason is because all Bruceys are hardcovers, and they're going out. What else? Got that. Oh, one more. Oh, thank you, legal-minded friends, Karen Cole. Very good. Thank you for bringing awareness. It's all my best I can give you. I'm cutting back on my, I'm cutting back. I'm really reassessing. I'm always reassessing. I'm reassessing my life at all times, as should you, about what I'm doing and who I'm participating with, how much I'm participating, how much I'm giving for this channel. I don't really know what I'm doing, except that I have things to say. I have something to say. I just don't want it. I don't want it to be work. And I want to be able to, I don't want to repeat myself. I don't want you to be bored, or I don't want to read, the latest news and react. That's just not what this is. It's something very different. This is original thoughts, original ideas coming from a different perspective. Was there something else I was going to tell you about? Oh, because you all have been so positive, I wanted to tell you that Brucey has been great, and you guys have been very supportive. You need to get it for Christmas. Please consider one of my books, Ideas and Answers in Law. If you're a law nerd, you really love this one, get this one, because I got them sitting over here ready to mail to you. Only get them here at stevegosney.com. But I've also put up a Give, Send, Go campaign for my next children's book, which is going to be called My Difficult Dog. And so I will probably do a stream on that. I don't know, probably maybe after Christmas when I start promoting it, but the Give Send Go campaign is up. I'll show you where it is on the little website here. So if you want to help me get it done, I've got a goal. The thing is, these Christmas books, I mean these children's books, require a lot of upfront money to get it funded for the illustrations. Okay, so here's my little shop, right, with the books. Okay, if you go up here to friends, and it brings up my buddies, and up here, see, there's Jackson. That's my difficult dog. If you click there, there's the Give Send Go campaign, and it will give you. It actually has the full text of Jackson, which is my difficult dog, along with the biblical references 1 through 15 of each one of these statements here. Each one of the statements in the story will be connected to a biblical quote, a biblical quotation, so that as you read it with your child, you'll be reading a biblical quote along with the Jackson story. Now it needs to get illustrated. There's Jackson. So that's how if you want to help out with Give Send Go, feel free. It's going to be 6 months, I think, but I mean, I don't know. It's going to be a while before it gets fully funded, because it's an expensive proposition putting together these children's books. Because these here, I write everything front to back, do all the publishing, all the layout, everything. This here, I really like. I hope when you see it, the illustrations are great. For sending my Brucey book, thank you, KLI. My niece is going to love it. Did you get it already, KLI? Did you get it, or are you just saying thanks for sending it? Oops, there's my tea. Got it. Oh, and thank you, Harris Tweed. Harris Tweed, I love the kitty. Thank you for this masterclass. Just purchased Ideas and Answers plus Death Penalty Debates. I look forward to those reads. Thank you very much. Well, if you do like this content, it's in Ideas and you can really, this is a document that I designed to be used by criminal practitioners. So thank you for getting it. And look, you just got, I know they're arriving. There's a couple, they should be getting today and tomorrow. The first wave, there's like 44 more that are coming out that I have to ship out on Friday. So if you didn't get it. All right. So that was nice, huh? Pretty good. Got it? Good. Oh, KLE got it. Oh, Chris Ladd got it. See there. If they're coming in, they're coming in. Oh, and I wanted to say a special shout out to my buddy, Patrick Finnegan. Patrick is one of my biggest supporters, and he provided a lot of the funding for Brucey, along with Let's Go Brandon, Aussie Overlord, Steph the Ultra Nerd, and Jeff from Legal Vices, and the Give Send Go supporters. And he's a good friend, and he was very helpful for me to kind of aligning my brain. I'm getting back to work, and I'm always reassessing, and you should reassess your life too. If you're going a direction that you don't feel comfortable, if you feel like you're on the wrong path, you have the choice to change that path, right? So exert your will, take control, do the best you can, and be the person that you want to be, not the person that you're condemned to be. All right. So if you can improve yourself, just take a little step and make yourself a little bit better every day. All right. Hey, God bless you all tonight. And maybe next week I'll do another masterclass. Maybe I'll do it on the one witness one, or I don't know. Well, I'll find one. But this battery one is really important because it's so common and so misunderstood and so widespread. And thank you for the super chats. And thank you to the replay guy, the replay crew. You know what we should do? We should look for somebody who's streaming now that we can do the whole Ghazni raid thing. That's always fun, isn't it? I got to get my tea here. You know who's going live right now? Let's see. Steph the Ultra Nerd. Let's do a Steph raid. All right. So this will be fun. Okay. Let me figure out how to do this. Steph the Ultra Nerd. I'm going to do it this way. Okay. All right. We're going to do our raid, right? You know how to do that, folks. Oops, darn it. Messed it up. Okay. I love doing this. You got to go Ghazni raid on Steph, because Steph was a big part of getting my book done. Okay. content. It's so tricky to do this stuff. The StreamYard is funky. Customization, redirect. Okay, this is gonna be fun. Oh man, I need to add to my community settings. Oh well, darn it. We'll do it later. Hey, have a good night.